Idiot cops may think they're above the law, but what happens when they face immediate consequences in court? Here are 4 times when idiot cops got instantly killed in court.
As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served.
This is former Officer Derek Chauvin from the Minneapolis Police Department. On May 25, 2020, Officer Chauvin responded to a call from a store named Cup Foods clerk in Minneapolis, Minnesota, when he suspected that a 46-year-old dark-skinned individual might be using a counterfeit $20 bill. Mr. Floyd was sitting in a car with 2 other passengers when police officers removed him from the vehicle and handcuffed him. Officer Chauvin murdered Floyd by pressing his knee to Mr. Floyd's neck for 9 minutes and 29 seconds while Mr. Floyd was handcuffed and lying face down in the street. Mr. Floyd repeatedly pleaded that he could not breathe. During the final 2 minutes, Mr. Floyd became motionless and had no pulse, yet Officer Chauvin continued to press his knee on Mr. Floyd's neck and back, even as emergency medical technicians arrived to provide treatment. Officer Chauvin was later fired and charged with second-degree murder, third-degree murder, and second-degree manslaughter. Watch how the sentencing goes when Officer Chauvin faces the court.
I wanted to thank everybody for being here and for providing the input you did. Not just the people who were in the courtroom here, but also those who provided written statements, both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today, and it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief because most of it's going to be in writing. I have a 22-page memorandum that is going to be attached to the sentencing order. And why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case, is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determined the sentence in this case. What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever, because it's not the appropriate time. I'm not basing my sentence also on public opinion. I'm not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases. And so, Mr. Chauvin, as to count 1, based on the verdict of the jury finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2 paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute Section 60904, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You are granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition, or explosives for the remainder of your life. Provide a DNA sample as required by law. Register as a predatory offender as required by law. And then you will receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything for the defense?
No, Your Honor.
All right. Thank you. We are adjourned.
Officer Chauvin was sentenced to 22 and a half years in prison for the murder of George Floyd, whose final moments under Chauvin's knee sparked the largest outcry against racial injustice in the U.S. in generations. However, Mr. Floyd's family members and others expressed disappointment with the sentence as it fell short of the 30 years that prosecutors had requested. With good behavior, Officer Chauvin could be eligible for parole after serving 2/3 of his sentence, which is approximately 15 years. This incident reignited the Black Lives Matter movement across the United States. If you think this was the only cop who got instantly killed in court, wait until you watch this next case.
That's something that we'll be dealing with at a later date. But for today's purpose, what the state would be asking for is a cash or surety bond. We would request a bond of approximately $50,000. And we also believe that based upon the statements that Mr. Underwood has made, intimating potential harm towards his child's mother, we believe that GPS monitoring, ankle monitor, is appropriate in this case. We would also ask that the bond specifically include provisions prohibiting him from going to her place of work and to her residence.
This is former Deputy Joshua Underwood from the Oconee County Sheriff's Office. On some day in early 2019, Deputy Underwood had reportedly locked himself inside his apartment in the Oconee County apartment complex. He forced a response from a SWAT team. Initially, some deputies tried to insist he exit the apartment. However, when they entered his apartment, they found him in the back room and he refused to leave while armed with a deadly weapon. Shortly afterwards, the South Carolina Law Enforcement Division was called to the scene, resulting in the surrendering of Officer Underwood. Officer Underwood was charged with resisting arrest and was kept in Oconee County Detention Center. His bond was set at $50,000. He showed up in the court for a bond hearing where things escalated quickly.
I'd like to hear from the Solicitor's Office and the Sheriff's Department before I make any decisions regarding bond for Mr. Underwood.
Yes, sir. May it please the court. Judge, just to clear up any issues regarding the warrant, the warrant is resisting arrest. However, I think what Mr. Underwood's maybe misunderstanding about that is that the resisting arrest also encompasses resisting the service of process or a writ. That is the specific portion that is being dealt with in this particular case. This situation arose when representatives from the Sheriff's Office went out to the residence where Mr. Underwood was staying and attempted to serve him with paperwork for an eviction. Mr. Underwood refused to accept that paperwork, so at that point, officers came back, obtained that warrant, and went back to serve that warrant. So that's how we got to where we are with regard to the warrant. Living with him at that residence, and I believe the primary person at that residence is the mother of Mr. Underwood's child. I don't believe they're married, but they do have a child in common. Certain statements were made while the situation was going on yesterday with regard to the standoff. A gun was obtained by law enforcement at the time of the arrest. Mr. Underwood did say that was his weapon and intimated to officers that it was not for use on officers, but it was for use on his child's mother. Given those circumstances, there was also some marijuana in the residence that was turned over to narcotics as well at the time of the arrest. I don't know that any charges have been made with regard to those drugs. That's something that we'll be dealing with at a later date. But for today's purpose, what the state would be asking for is a cash or surety bond. We would request a bond of approximately $50,000. And we also believe that based upon the statements that Mr. Underwood has made, intimating potential harm towards his child's mother, we believe that GPS monitoring, ankle monitor, is appropriate in this case. We would also ask that the bond specifically include provisions prohibiting him from going to her place of work and to her residence. And certainly we can furnish the addresses to the monitoring company so they can go ahead and plug that into the monitor so they'll be notified if Mr. Underwood goes to either of those places. I think that's all we're asking for today. Any other issues certainly can be taken up at a preliminary hearing or at the appropriate time later on.
Okay, thank you.
Thank you.
Officer McCreary?
I really don't have anything else to add to what he said.
Nothing to add?
No, sir.
Okay, thank you very much. All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable accordingly. I'm going to impose that cash or bond for your release.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything that he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity of...
What reason is your
Sir.
Why are you standing behind that you're gonna
Mr. Underwood,
firearms?
Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
Hey, you can't look at me, can you? You can't look at me, can you?
Do you have any questions?
No, sir.
Okay, sir. Okay, thanks very much.
The meeting initially proceeded when the judge asked the lawyer to explain the charge. The lawyer explained that Officer Underwood mistook resisting arrest and also covered resisting the service of process. He also informed me that the actual resident of the apartment was Officer Underwood's former partner. The lawyer said that the state requested a bond of almost $50,000 due to Officer Underwood's threats to her former wife or his child's mother. Some drugs and intoxicants were also found during the arrest, which the judge said would be dealt with at a later date. If you think this was the maximum a cop and get instantly killed in the court, then you probably aren't aware of this next case.
Again, I'm sorry, I don't remember exactly what I said to the detective immediately after the shooting. I was in shock.
How about what you said to Detective Walsh on the way there? Oh my God, we're gonna have to shoot the guy. Why'd you say that?
I didn't talk to a Dr. Walsh.
A Detective Walsh.
Officer Walsh, ma'am.
This is former Officer Jason Van Dyke from the Chicago Police Department. On October 20th, 2014, Officer Van Dyke was involved in an incident where he was found having killed a dark-skinned teenager named Laquan McDonald. Officer Van Dyke allegedly shot Mr. McDonald 16 times during the incident that caused his death immediately. The dashcam video of the incident was the key evidence of the murder and was released almost a year after the incident. Officer Van Dyke explained that Mr. McDonald turned his torso toward Van Dyke and waved the knife in his direction. Officer Van Dyke testified that he continued shooting because he saw Mr. McDonald's shoulder rise and noticed that Mr. McDonald still had the knife in his right hand. Watch his testimony in court.
Where in that video does it show Laquan McDonald trying to get up?
I can't tell you, it's not in front of me.
Well, you just saw the video. Was there any point in that video where Laquan McDonald was trying to get up?
From that video, I may not show it, but that wasn't from my perspective, ma'am. I was coming at a completely different angle.
And you told Detective March that night that you continued to shoot at him once he was on the ground because he was pointing the knife at you. Is that correct?
You know, I'm sorry, I don't remember exactly what I said immediately after this shooting to the detective. I was still in shock. I know I gave him a summary of what happened that night.
So you don't recall that you told him that you continued to fire your weapon at McDonald, who was on the ground, as McDonald appeared to be attempting to get up, all the while continuing to point the knife at you?
I'm sorry, I said this to the detective?
Yes.
Again, I'm sorry, I don't remember exactly what I said to the detective immediately after the shooting. I was in shock.
How about what you said to Detective Walsh on the way there? Oh my God, we're gonna have to shoot the guy. Why'd you say that?
I didn't talk to a Dr. Walsh.
A Detective Walsh.
Officer Walsh, ma'am.
Officer Walsh?
Yes.
Okay. Why'd you say to him, oh my God, we're gonna have to shoot the guy?
I thought the officers were under attack.
Okay, at the point that you thought...
Ma'am, I'm still
No.
trying to answer. I thought he was under attack and the whole thing was just... It was shocking to me.
Shocking? You responded to several calls over your years of people with knives, correct?
I've encountered a few, yes.
And the only thing that you knew at that point was that they had called in, popped a tire, and somebody had a knife, correct?
I had heard over the radio that he had slashed the tire, yes.
It doesn't, over the radio never says slash the tire, does it?
I now know that, yes, I misinterpreted it at the time.
Okay, so, but what you heard was pop the tire, right?
At the time, I thought I heard slashed.
And when you see McElliott and Gaffney in the Burger King parking lot, you know they're not under attack, correct? So it's your testimony that he's not walking towards a fence?
I'm sorry?
It's your testimony that he's not walking towards a fence?
That's my testimony. It looks to me like he's going from one side of the dotted line to the other side of the dotted line.
Now, and it's right there at that point where you say that he raised his arm up to around his chest?
At this exact point,
Yes.
I don't know.
Now, you had a radio on that night, right?
Yes, ma'am.
You knew a taser car had been called, correct?
Yes.
You know, somebody had responded that they were coming, correct?
I just heard that a car had responded. They were coming from a distance, but I never heard once over the radio that a taser unit was responding.
Well, I believe the dispatch actually says when they're on the radio, they say that they're near Mulligan and Archer, correct?
I don't remember the exact cross streets now.
And then the dispatcher comes on and says, anybody closer with the taser, right?
I don't remember.
And so when you got out of that car that night, you could have called and said, hey, where's the person with the taser, right?
Hypothetically, you could.
Well, it's not a hypothetical question. You could have called and said, where's the car with the taser, right?
Objection, it is a hypothetical question.
I'm sorry, what's your objection?
It is a hypothetical question. You could have called, it's hypothetical.
Overrule.
Hypothetically, anybody on scene could have called.
No, question is you. You could have called, correct?
It was a very chaotic moment,
The answer is a yes or no.
and it doesn't just stipulate a yes or no answer, it's a very complicated answer. There's a lot going on at that moment.
You didn't even have to get out of the car at that point, did you?
You could say I also didn't have to go to work that night.
No, that wasn't the question. The question was, you didn't even have to get out of the car, correct?
As an officer, I know now and what I thought at that time are two different things.
Now, you didn't know anything at all about LaQuan McDonald that night, did you?
Just from the actions I observed of him and his actions that I heard before seeing him.
That's all, right?
Yeah, I don't think I ever met him before.
Now, you stopped shooting because your gun was empty, correct?
Yes.
And it wasn't because you thought the threat was over with, right?
I'm sorry.
It wasn't because you thought the threat was over with, right?
Between the time I stopped shooting and the time I reloaded, the situation had drastically changed.
Really, what changed?
It was no longer a threat by the time I reloaded my weapon and brought it up to the ready position.
Why wasn't he?
In those couple of seconds, he had stopped moving.
And it's actually your partner who said, hey, I got this, right? You were ready to continue to shoot him.
Absolutely not.
Absolutely not? Your partner didn't tell you, hey, Jason, I got this?
You asked me a compound question. I was asking the second part of the question. He did say, yes, he did say, Jason, I got this.
Officer Van Dyke claims that the video shown does not accurately reflect his perspective, as it captures the scene from behind his head. He reiterates that he stopped shooting when Mr. McDonald fell to the ground and does not recall telling detectives that he continued firing because Mr. McDonald was trying to get up. Officer Van Dyke admits that he only stopped shooting because his gun was empty, not because he believed the threat had ended. Officer Van Dyke was sentenced to 6 years and 9 months in jail and 2 years of mandatory supervised release. He was found guilty of the second-degree murder charge and 16 counts of aggravated battery. The prosecution wanted the sentence to at least consist of 18 to 20 years in prison. If you think this was the last cop who got instantly killed in court, then you probably haven't heard of this next case.
Just so that you know, what is in evidence and what I will allow in evidence up until this point is the point at which you objected, or pretty close to it, when there was an officer just, I believe to be Officer McElroy, just turning the corner, just at the corner and turning, walking back on the sidewalk. Up until that point, all of that's already in and will stay in evidence. What we're talking about is from the point at which he turns the corner and anything that transpires after that.
This is Officer Michael Sipple from the Rochester Police Department. In May 2018, an individual named Christopher Pate was walking on Bloor Street in Rochester, New York, when officers stopped him, mistakenly identifying him as a wanted suspect. Mr. Pate stated that he provided ID but was nonetheless grabbed, stunned with a taser, handcuffed, and beaten. The charges against him were later dropped, and one of the officers involved, Officer Sipple, was found guilty of assault during a bench trial and subsequently fired from the Rochester Police Department. Watch the court hearing when he is summoned to court.
The exceptions by way of admissions or statements against penal interest, any statements that might be attributable to Mr. Sipple really have they're vague. It would force the fact finder to speculate as to where they fit in and to what. In addition, I'm not sure, there's large portions here where of this tape where Officer Sipple's not there. So any statement that may have been made is just kind of out there as far as to go to anyone's state of mind. He's not even present, and you see that in the video. There's other very, in my opinion, statements attributed to the other individual in the tape that I would submit to the courts more prejudicial than probative. In fact, it has no probative value to the issue at hand. So I'm asking the court to preclude everything after the res gesti or after the alleged assault, and that's where the officers then separately go around the point.
Just so that you know, what is in evidence and what I will allow in evidence up until this point is the point at which you objected, or pretty close to it, when there was an officer just, I believe to be Officer McElroy, just turning the corner, just at the corner and turning, walking back on the sidewalk. Up until that point, all of that's already in and will stay in evidence. What we're talking about is from the point at which he turns the corner and anything that transpires after that. And based on my making that clearer than perhaps I did earlier, anything more you want to say?
No, thank you.
Ms. Farmer.
Your Honor, the people would submit that, number one, the entirety of the video goes to complete the narrative of the events, and that there's actually numerous lines of dialogue that occur throughout the portions of the video that we watched in camera that are relevant to the ultimate issue at hand, are relevant to the reasons for the arrest of Christopher Pate, and are relevant to the material issue of this case. And that, in fact, the other images on that video are exceptions to the hearsay rule, in that they are excited utterances and go to show the state of mind of the victim as well as the other people that are in that video. and that I do disagree with defense counsel that some of the statements contained are declarations against penal interest. And due to those reasons, we would ask that all the portions of the video be accepted into evidence.
The basis for excited utterance, to raise that as an exception to the hearsay rule, a lot of what is on that tape is hearsay. It would be introduced for the truth of the matter asserted in the statement, or if it's not hearsay, then I presume somebody would be asking it to be introduced as a verbal act or an act of independent legal significance, not for the truth of the matter, but because it completes the narrative or it explains what somebody did, the classic reasons why you would allow a statement not for the truth of the matter asserted in the statement. And the reason that I stopped and asked, where are we on this tape, on at least 3, if not 4 occasions, is because in listening to it, there, as a judge, became a question in my mind as to whether or not this did tend to prove or disprove a fact in issue. As you raise the excited utterance, there at least becomes a point where, as a judge, viewing that as an objection, I have questions as to whether or not the individual whose voice can be heard may be saying things knowing that what's transpiring is on tape. There is, in the court's view, a marked change in the tone, tenor, and timbre of that person's voice. What is said might lend one to believe that that is not a statement made in the heat or excitement of the moment, but rather a statement made for another purpose. So even if I were to accept that some of the statement made were an excited utterance, there becomes a point where clearly I would rule against you on that theory, that it is not an excited utterance, but it is after some reflection as to the situation the person may find themselves in and does not fall within the parameters.
Do you have your ID, sir? Do you have your ID, sir? Sir, I'm talking to you. Do you have your ID? I just showed you what I had. Look, you don't need to see what I do. Put your hands behind your back. You have my ID. Put your hands behind your back. You have my ID. Put your hands behind your back. Anything wrong to you? You put your hands behind your back. You have my ID. You have my ID. Now we're going to do it this way. Put your hands behind your back. Do it now. You have my ID. Behind your back. You have my ID. You have my ID. Put your hands behind your back. You have my ID. Put your hands behind your back. Put your hands behind your back. Under arrest. You're under arrest. Put your hands behind your back. Stop. Yes, yes, stop.
All right, ladies and gentlemen, we're going to go back in session. At this point, I'd ask you to wrap up the conversations that you're having, if you would, please. First, Mr. Zimmerman and Wadir.
If I may.
Yes, go ahead.
The judge concludes that the jury will not see the full footage, allowing only specific parts if they are deemed relevant and not overly prejudicial. The judge discusses the relevance of the video evidence, weighing whether parts are prejudicial or if they qualify as exceptions to hearsay rules. Later, Officer Sipple was sentenced to just 3 years of probation with no jail time. It's meritorious to see idiot cops getting instantly killed in court for their evils. If you enjoyed this video, make sure to like this video and subscribe for more. Goodbye.